ability to impact how consumers are going to interface with the digital world for a long time to come. And I want to get to those areas of agreement, but there is some ugliness we got to deal with. Now, you guys putting in the names of reporters in a correspondence to Twitter was solely predicated based on anonymous news sources, right?
It was based on reporting that.
Right, and we would agree that anonymous reporting is not a sufficient predicate to target, to send letters about journalists, right?
Congressman, yeah, the goal was third parties, but this is good feedback for us. We want to make sure we're not in any way suggesting that we're interested in, affecting journalists' work. It's really about privacy and security. So
I appreciate your acknowledgement that is not the way we ought to do things. As someone who has seen ugly government action emerge out of anonymous reporting, perhaps I'm a little sensitive to that, but I'm glad that you've made that acknowledgement. Let's get on to the important work that you are doing. Millions of Americans have a correspondence saying, quote, during a 3-month period in 2017, a Ring employee viewed thousands of videos of female users in their bedrooms and bathrooms, including videos of Ring's own employees. There was also at Ring, according to the FTC, an unauthorized tunnel that allowed a Ukraine-based contractor to access consumer videos. An incident where a Ring employee gave information about a customer's to their ex-husband was also something that you uncovered. You also state that bad actors at Ring took advantage of the camera's two-way communication functionality to harass and threaten people who used Ring cameras. There was a case where an 87-year-old woman at an assisted living facility was sexually propositioned through Ring's two-way features. Kids were subject to racial slurs. A hacker got in and threatened a family with physical harm if they did not pay a Bitcoin ransom. And one hacker even communicated through the two-way feature to a customer that they had already killed the customer's mother and, quote, tonight you die. What is going on at Ring?
So as you noted, we recently took enforcement action precisely because of these very serious lapses in data privacy, which endangered Americans in their day-to-day lives. Overall, looking at some of these surveillance devices and how they can be misused and abused is a top area of focus for us because people's privacy is paramount.
Yeah, I thought that when people got Ring, it was to enhance their personal security, not to have their 87-year-old relative in an ALF sexually propositioned, their children to be slurred at, and then to be told that they were going to be killed if they didn't pay Bitcoin ransom. So thank you for that effort. Let's go to another evil company, Kochava. Kochava is one of these data brokers that you're going after, right?
That's right.
And the American people should know that Kochava geolocates where people go to church, and then they sell that data to commercial enterprises, right?
That's right.
That's real creepy, isn't it?
I believe most people would have that reaction, yes.
I got onto the FBI director yesterday for their creepy FISA activity, and now we have Kochava literally selling to people, oh, well, this is a Baptist, this is a Methodist, this was someone who goes to temple. Are you going to get these people and stop them?
So we have a pending lawsuit. We filed it last year. The court dismissed it. They gave us the opportunity to refile. We just refiled an amended complaint. And we think it's urgent to act here because, the types of stigmatization and harms that can stem from being able to track and sell people's sensitive geolocation information is just critical for us to be addressed.
We didn't like it when the FBI was wanting to infiltrate the Catholic churches, and I don't know that I want the data brokers to do the same. And by the way, we've even seen how the FBI is using the data brokers to do an end run around the Fourth Amendment. So I really want to encourage your work in this space, and I hope that your litigation against Kochava is something that creates precedent. And you know what? There's been criticism of some of your losses in court, but we as sophisticated lawyers know sometimes that a motion to dismiss an initial complaint can create a pathway to an amended complaint to achieve relief. And so if the laws are insufficient to stop data brokers from selling information about where my constituents worship, and if the laws are insufficient to stop Ring from these activities, I really hope you'll work with us to change those laws. And all of Mr. Buck's points are really central to this, because if Congress is bought off, if people are just coming here to beat you up over what email account you use or what trip you've been on to Europe, I think it misses these things that are far more central to the life that our constituents lead. Thank you for your work.
I would just say worse than Coach Chavez selling, it's the FBI is probably buying it. That's the scariest part. So
Agree with both.
I appreciate.
Well, let's get a bill, Mr. Chairman, to deal with those data brokers.
We're working with the gentlelady who just went right before you to do just that. That is something that I think this committee can hopefully agree on. And I neglected to mention this earlier, Madam Chair. We've been at this hour and a half. If you need a break at any time, just let us know. If not, we can keep going because we can get up and leave, but you can't. So you let us know if you need a break. With that, if you're willing to keep going, we'll go to the gentlelady from Pennsylvania for 5 minutes.
Thank you. Chairwoman Khan, I want to start by thanking you and the FTC for your work to protect American businesses and workers and consumers on issues ranging from privacy concerns to deceptive business practices to unwanted telemarketing and robocalls, to fraud and financial exploitation that targets seniors, service members, veterans, and those in recovery from opioid disorder. Those are all really important issues, and we hear from our constituents regularly about all of that. You don't have an easy job. It's not made any easier when bogus claims are levied against you in congressional hearings. Every day, some of our colleagues seem to be trying to prove the legal maxim that if you don't have the law on your side, argue the facts, and if you don't have the facts either, just argue. So we appreciate your patience in responding to a lot of fact-free questions. I want to focus my questions on hospital consolidation and the growing problem of private equity firms buying up hospitals and healthcare groups. In the Philadelphia region in recent years, we've had 2 major hospitals purchased by private equity firms, after which those firms mismanaged the healthcare functions of the hospitals, stripping them of their assets, and then either closing the hospitals or putting them up for sale. This was Hahnemann Hospital in 2020, which was closed in the middle of the COVID pandemic after a private equity-backed real estate developer bought it. That left a gaping hole in our frontline healthcare system in one of the poorest cities in the country. And then currently, the Crozier Health System is teetering on the verge of bankruptcy while hemorrhaging talented staff and medical practices after a private equity owner stripped the system of assets, undermined its relationships with medical staff, and has reduced access to medical care, particularly maternity care, emergency services, and behavioral health care. The impact on our local healthcare system has been so extreme, we've seen local Republican politicians calling for government intervention in this private equity firm's hospital business to prevent it from closing or bankrupting the system and its constituent parts. We're also seeing this troubling national trend in which private equity firms have embarked on a buying spree to scoop up smaller healthcare groups. And there was a revealing report from the Petra Center at UC Berkeley and the Washington Center for Equitable Growth detailing the trend of private equity firms buying up multiple doctor groups in a city and then using that consolidation to raise prices. So we're really concerned about this trend that's reducing access to healthcare and then raising prices. So what is the FTC's response to the call for more regulatory scrutiny over these transactions, and how can it increase oversight and enforcement activities to ensure that we preserve market competitiveness in our healthcare system?
This is such an important issue, Congresswoman, and we at the FTC, our team has done a fantastic job really addressing hospital consolidation, in particular in local markets. We've had a whole set of successes really spanning hospitals trying to merge in ways that would have hurt patients. Our staff was able to block that transaction and the parties walked away. I think you're absolutely right, though, that today we're seeing different types of strategies, including the incursion of private equity. I recently met with some emergency medicine physicians who had come from across the country who were sharing how the incursion of private equity is really harming the quality of healthcare for people in very material ways. So that's something that's on our radar. We're trying to figure out how do we update our tools to be able to address this. We recently issued some proposed updates to what's known as our Hart-Scott-Rodino form. Sounds very technical, but it's basically the information that parties have to provide us when they're looking to make an acquisition. Partly, those changes would give us more insight into some of the type of roll-up strategies that you're mentioning so that we know on day one whether a private equity firm has this history of roll-ups that should put us on high alert. So definitely something that we're looking at closely.
Okay, I've got a couple more questions on that same topic that I'll save for the next round or submit to you, but I did want to yield 30 seconds to Representative Jayapal.
Thank you so much, Representative Scanlon. I just wanted to say quickly, before I ask my question, that I was not trying to attack the ethics of your ethics officer. I was trying to point out the hypocrisy of those on the other side who raise that you have a conflict of interest and don't mention the other issues that might exist there. I just want to go to evil actors because there's one more I really want to talk about, and that is tax preparation companies. For years, Intuit, the maker of TurboTax, flooded consumers with ads promising free tax filing services, only to trick and trap them into paying, which is why taxpayers pay $250 on average each year just for the privilege of filing their taxes. So state attorney generals have won taxpayers money from Intuit, and the FTC has also taken action. Can you just speak about that?
Yeah, absolutely. So last year, the FTC brought a lawsuit against Intuit for those very types of deceptive practices that are laid out in our complaint. That is still pending, but I couldn't agree more that, claims of something being free, but then ultimately it not being so really hurts people.
Gentlelady's time has expired. Gentleman from Louisiana is recognized for 5 minutes.
Thank you, Mr. Chairman. Chair Khan, I'd like to begin with policies related to diversity, equity, and inclusion, DEI, that you've instituted at the FTC during your tenure. Last month, you implemented a so-called Equity Action Plan that calls on the FTC's Bureau of Competition to, quote, update its case selection based on this new criteria. But allowing the Bureau to wade into picking cases based on these amorphous terms like equity is an idea that we believe is fraught with problems. You've also hired staff who have published articles on the topic of, quote, anti-racist antitrust. Can you explain to the committee what that means? What does that term mean?
Congressman, it's not a term that I've used. I can say generally, I know that there is a lot of worry that concentrated economic power hurts everybody, all communities, and that the FTC needs to be mindful to make sure that our work is focused on the harms that is affecting everybody.
Everybody, right? So anti-racism should not play a factor in competition and consumer protection policies at the FTC, right?
Congressman, we bring our lawsuits based on the law at hand. We look closely at where we
But
might.
this is not one of the factors. Anti-racism is not going to be used under your watch, right?
There are instances in which Congress has asked the FTC to look at whether particular communities are being defrauded. In those instances, we follow what Congress has told us to do. But otherwise, we just follow the general laws. That's correct.
Okay, a senior staffer at your FTC recently attended an event, gave a speech, and discussed, quote, applying a gender lens to antitrust, in which the senior staffer praised a cross-agency equity team. Are you applying a gender lens in the context of antitrust analysis now?
To be honest, I'm not really sure what that means.
We aren't either. I hope you're not using it. Okay, is there a cross-agency equity team? Was she accurate about that?
We have a lot of cross-agency teams. There are teams that are focused on how you make the FTC a better place to work, including by making sure that certain.
Okay, but equity's not in your bailiwick now. You don't have a team dedicated to that, correct?
We have a cross-agency team that's thinking about how to make sure that the FTC is.
Okay, she just overspoke. Okay, I got it for time. Don't you think reorienting the FTC from protecting consumers to protecting favored groups, that idea would run counter to what the FTC's mission is, right? I mean, you said it to apply to everyone, right?
That's
you shouldn't
right.
be injecting these, I guess it's progressive policy initiatives that we're concerned about. The FTC has a really important mission, and we don't want you to get off course. Last year, on a party line vote, FTC also expanded its authority under Section 5 of the FTC Act well beyond what any previous FTC has done over the last 40 years. In November 2022 policy statement, that power was expanded to unfair methods of competition that is described as, quote, conduct that goes beyond competition on the merits, and that, quote, here's the key, even when conduct is not facially unfair, it may violate Section 5. Following that decision, former Commissioner Christine Wilson stated, this is what she said, quote, the Commission has now created the authority to summarily condemn essentially any business it finds distasteful. That is an extraordinary power. And it's very concerning because unfair is an amorphous and very subjective term by nature. Are you using Section 5 authority to determine what is unfair, even if it's not facially unfair, whatever that means?
Congressman, we look very closely at the text of the statutes that Congress wrote. The text of the FTC Act instructs us to prohibit unfair methods of competition, We have to take those words seriously. When putting together that policy statement, our team looked closely at decades of case law to try to understand how have courts interpreted what this means, and the policy statement reflects that.
Okay, really quickly, there's an example recently, I believe you're in the process of ending non-compete agreements as an unfair method of competition, and that decision could go into effect next year, is that right?
We got 24,000 comments on the proposal. We're reviewing them and determining how to move forward.
Or would you favor a blanket ban on all non-compete agreements? Is that your position?
So the proposal bans the vast majority of non-competes with a few exceptions, one of which is non-competes that are included as part of the sale of a business.
Okay,
So
let me ask
that's
you a
the
question.
current
Have
proposal.
you ever run or worked in a small business?
I personally have not.
Yeah. So do you think it's reasonable for entrepreneurs and small businesses who spent considerable time and money developing practices to better compete against their rivals to find your ban on non-compete agreements unfair?
We'll be eager to hear from them. I know we've gotten a lot of input. The other thing I'll say we hear from small businesses is that non-competes make it difficult for them to compete. Because if they're trying to enter a market and compete with some of the big guys, but the big guys have locked up all the workers through non-competes, that hurts the small businesses. So we really have heard multiple views on this issue.
I'm out of time. Yield back.
Thank you, Mr. Chairman. Beware of that profound enemy of the free enterprise system who pays lip service to free competition, but labels every antitrust prosecution as a persecution. Those words are uttered by President Franklin Delano Roosevelt 90 years ago. And I've listened to most of today's hearing, Madam Chair, and of course we're grateful that you're here today. I've listened to many of the criticisms that have been made by my colleagues of your leadership at the FTC on the other side of the aisle, not all my colleagues, but most of them. And the vast majority of these criticisms have nothing to do with your ethics or your integrity or your approach to the job, and everything to do with corporate power and the realities that you have pursued your duties as the chairwoman of the FTC in a way that puts the best interests of the consumers first. And that is a new approach at the FTC. I don't want to belabor the point because I have some substantive questions for you, but I'll ask for unanimous consent later at the conclusion of my remarks and our colloquy here for an article in the Wall Street Journal from June 30th, 2023, the headline of which is Ethics Official Owned Meta Stock While Recommending FTC Chair Recuse Herself from Meta Case. We've spent a great deal of time hearing my colleagues talk about this particular issue. I will just simply echo the comments made by my colleague from Colorado and my friend, Mr. Buck, who I thought spoke very powerfully on this front. Only in Washington, D.C., can an individual, a regulator, who has no financial interest in the merger before her, be accused of an ethics violation by members of Congress who own financial, or have rather financial interests in the company that has petitioned for that, or is rather proceeded with that particular merger that is under review by the FTC on the basis of an opinion that was issued that didn't conclude that there would be a per se ethics violation for the commissioner in question to proceed with considering the matter, but nonetheless opined that there would be an appearance of impropriety, and of course that individual having a financial interest in the company that was involved in the merger. And I'm not commenting, I agree with Ms. Jayapal, on the propriety of the decisions made by the ethics individual or the ethics department more broadly. I'm simply opining on the state of affairs in Washington, D.C. Because for years we've had FTC commissioners who had real conflicts of interest. You didn't have any financial interest in Meta, right?
That's correct.
You've never worked for Meta?
That's correct.
The basis, as I understand it, for the objections by many of my colleagues and others is that you have a certain view when it comes to putting consumers first and ensuring that monopolistic power does not reign supreme in our country. And I just think it's unfortunate that some of my colleagues have taken that approach. I will say for my part, I'm grateful for the work that you have done at the department. I also am grateful for the work that your partners, and of course, other antitrust enforcement regulators, the Assistant Attorney General Cantor has done over the course of the last several years We, as you know, passed a bill on a bipartisan basis last year. It was my bill, the Merger Filing Fee Modernization Act, which I believe is going to strengthen your efforts and your ability and the efforts of your hardworking workforce within the FTC by changing the fee schedule for mergers, actually decreasing the fees for smaller mergers, but increasing the fees proportionally for billion-dollar transactions and giving you the resources that you need to fight for consumers on behalf of the American public. I wonder if you might talk a bit about that particular bill, its implementation, and the impact it will have on agency resources.
Thanks for the question, and thanks for your effort leading that bill. It was a much overdue effort to update the filing fees, and as you noted, make it clear that for larger transactions, there is a higher fee, for smaller transactions, a lower fee. We in part rely on those fees to be able to fund our enforcement, and so that's absolutely going to be making a difference.
Well, as I said, I'm grateful for the approach that you all are taking. I was proud to work on that bill with Representative Buck, who has been a champion on these issues, among other colleagues of mine on both sides of the aisle. And I think we look forward to continuing our work with you, Madam Chair, for years to come on this front. With that, I will yield back.
Gentleman yields back. Gentleman from Kentucky is recognized.
I thank the chairman. My constituents aren't contacting me worried about mergers between tech companies or that sort of thing. But one of the things I've been contacted about multiple times is the small independent grocers feel like their monopolistic practices being used against them. And Mr. Correa and I sent a bipartisan letter to you asking for an update because in November 29th, 2021, this is 17 months ago, the FTC ordered 9 large retailers, wholesalers, and consumer goods suppliers to provide detailed information to help you study the causes behind ongoing supply chain disruptions. And I appreciate you being willing to give us a briefing, but can you brief us today? Like, what have you found? And are you going to be able to help these folks who are complaining about they can't get products or there's discriminatory pricing, not based on quantity, but based on other things or different package sizes? What can you tell us here today?
Yeah, this is such an important issue, and we've heard from those independent folks as well. And it's partly what informed our decision to launch this study. We're moving as expeditiously as we can. As you can imagine, sometimes firms don't have an incentive to give us all the information we need as quickly as we need it, but we are moving ahead full speed and happy to be providing you with the non-public briefing to share what we've found so far. And Bill will be looking to make our findings public as soon as we can.
I hope that's soon. There's been 17 months since you asked them to give the information. I understand it takes them a while to get it to you, but I would hope we would get that very soon. Another issue that concerns many of us are these so-called pre-consummation warning letters. On August 3rd, 2021, FTC announced that it would send warning letters in connection with transactions it cannot fully investigate within the time provided by the statute before the deal closes. Well, now, why should people trying to do regular business be punished because it's taking you too long to do your job? And how many of these so-called pre-consummation warning letters have been sent by the FTC?
So the statute gives us only 30 days to look at a deal to determine whether we need to investigate it further. As deals have become more complex, that can be a very, very, very tight timeline. We've heard from some businesses that if we don't act within that 30-day period, the takeaway for them is that there are no issues and there are no concerns. So we thought it was important to put business on notice, to provide them clarity and transparency, that if there is a deal that we think raised concerns, but we weren't able to act within the 30 days, that we're putting them on notice about that, again, to make sure that the market has clarity on it.
Commissioner Phillips publicly suggested that within the first 6 months of this practice, over 50 letters were sent, and raised the question of whether any of those investigations actually remained open and whether this approach was simply a tactic to scare business. I'm worried that whether it's a tactic or not, that's the effect that it's having. It's having a chilling effect. And then when you issue one of these letters and then you never tell them whether the case is closed or not, kind of without doing anything, you've stopped transactions that would be helpful to Americans. I want to now yield back the remainder of my time to Chairman Jordan.
I appreciate the gentleman yielding. When the FTC attorney deposing Mr. Roque asked him to confirm that, quote, no one from the FTC directed you to reach a particular conclusion about Twitter's program, he explained to the contrary. There were suggestions of what they would expect the outcome to be. He testified that the FTC communicated to Ernst & Young. Again, Ernst & Young is the independent assessor, the fact finder that the FTC selected and made Twitter pay for, that he communicated to Ernst & Young that, quote, Ernst & Young under all circumstances will be conducting and issuing a report on behalf of the FTC order, and was very adamant about this is absolutely what you will do, and this is going to occur, and you will produce a report at the end of the day. The FTC was so adamant. Ernst & Young leaders feared that the FTC would take exception if they chose to withdraw from the case. So on the one hand, you're harassing Twitter, and then you're saying the guy we've selected, the entity we've selected, Ernst & Young, the accountant we've selected to be the fact finder, you better find what we want, and if you try to get out of it, we're going to retaliate against you. That is frightening. When we talk about the weaponization of government, this from the same agency that said, tell us all the journalists you're talking to, that's what we're concerned about, Ms. Khan. That's what has to change. You can comment if you want, but I'm reading from the motion filed today in court. And it's amazing to me, you don't even know this guy, you don't even know who this person is, and your lawyers deposed him. He's the guy that you set up as the fact finder, and you didn't know who he was. Did you sign off on any of those 12 letters sent to Twitter in that 10-week time frame?
Congressman, we're fortunate to have a lot of work underway. A lot of this work is delegated to the frontline staff that are able to move quickly and nimbly to make sure.
Yeah, but you're in front of Congress today, and you knew you're going to get questions about this, yet you don't know this. I find amazing.
It sounds like it was a late-breaking development in a filing this morning. It's not something that's on my radar. I'd be reluctant to weigh in on it in this setting without looking more closely at it. Happy to take questions for the record on it and engage later.
Not on your radar that you told, based on the testimony of this guy, that he felt there would be retaliation if Ernst & Young tried to get out of the agreement. Wow.
I yield back.
Wow. Gentleman yields back. Now recognize the gentlelady from Pennsylvania for 5 minutes.
Thank you. And before my 5 minutes, I ask unanimous consent to enter into the record what Mr. Neguse had hoped to enter. Ethics official owned Meta stock while recommending FTC chair recuse herself from Meta case. Thank you. Thank you, Mr. Chairman. Thank you, Chair Khan, for being here, for speaking with us today about the important work that FTC does to safeguard consumers and crack down on companies that would exploit them. I come from a perspective of, as a mother, as a grandmother, I care about exploitation of seniors, of children, of businesses, consumers generally. In your written testimony, you explained that FTC works to protect privacy and data security, fight fraud, including fraud related to opioid recovery, and ensure that domestic manufacturers and small businesses have a chance to compete fairly. Somehow Republicans are using this time in other ways. I apologize, I'm late to the hearing today, but I'm pretty sure I'm glad I missed some of what happened. I was in another hearing with Secretary Kerry on the climate crisis, so forgive me for coming late. I wanted to ask you about the issue around opioid addiction and abuse and what FTC is doing. I know that FTC recently returned $60 million to people suffering from opioid addiction. I know you know as well as I that the crisis, the health crisis, public health crisis in this country around the flood of opioids and opioid addiction is grave. 110,000 people died last year of overdose. That's 300 people a day. Can you tell us about your work, FTC's work, to try to protect consumers? Maybe this case, the $60 million case with Rectic, I don't know how to say that. Can you tell us about your work in that area?
Yeah, happy to. And we were, this is a newer authority that Congress gave us, and I've been pleased that we've been able to quickly put it into action. We brought a set of lawsuits using this authority to make sure that if companies are deceiving potential patients of opioids recovery facilities, that we are acting quickly to prevent that deception. We brought a case against a firm called R360 because we found that they were engaging in some of these deceptive practices in ways that were harming opioid recovery patients. We recently brought another action that also noted that deception around tobacco addiction recovery is also illegal under the statutory authority. So we're working hard to make sure people are being deceived in ways that are illegal under this authority. We're acting and we're getting the money back.
Well, I thank you for that work. I hope you will continue in a robust way. And for full disclosure, I have a son in long-term recovery, 10 years in recovery from opioid addiction. We've lost too many others to this problem, and the deceptive practices are so egregious that it's very upsetting. I wanted to move to, if I have some time, I do, good. Pharmacy benefit managers. They operate behind the scenes. Consumers don't really know what they're all about. They're a middleman in the drug market and determine patients' access to medications as well as the prices consumers pay. In this role, PBMs have the power to raise prices and are part of the reason that consumers pay 20% more than they should for generic drugs. Can you speak to what FTC is doing around the issue of PBMs and disclosure to consumers and cracking down on the price hikes?
You're absolutely right that these firms are oftentimes behind the scenes, so people are not directly interacting with them, but oftentimes their decisions are determining what medicines make it onto what's known as the formulary. And unfortunately, we've heard reports that suggest that, rebates between, the drug manufacturers and the people is going to the pharmacy, they're not actually able to get it, having to pay more for the branded drug. And so, we've said in our policy statement, we are very concerned about that and are looking at it.
Yes, and how can we interrupt that? Can FTC have some rulemaking, some effectiveness in interrupting that blockage of information to the consumer?
So we're looking closely at whether, there may be violations of the FTC Act. The Robinson-Patman Act also prohibits certain types of kickbacks, I believe under 2C of the Robinson-Patman Act. So we're really laying out all of our authorities and making sure we're using them to address these issues because, oftentimes we hear from insulin patients about how they haven't been able to afford life-saving medicine, potentially because some of these tactics. So we recognize the urgency of this work.
Again, on behalf of consumers and seniors and kids out there, thank you for your work and the work of your entire team. I yield back.
Gentleman from Arizona is recognized.
Thanks, Mr. Chairman. Thank you for being here today. I will say I wrote down something you said. I think I got the quote exactly right. I wrote it down because not only was it, I think, substantively meritorious, but it also was alliterative. People's privacy is paramount, close quote. If only the FBI leadership believed and acted that same way, I would be happy. I want to ask you first about the EU's Digital Markets Act. You previously commented and opined in response to Mr. Klein's questioning. He asked you how much spent. I think you said you don't know. I wonder how many employees or personnel are working on the EU Digital Markets Act?
So my understanding is we currently have one employee that's detailed to Brussels. These details are routine. They've gone on for many years. They help improve, coordination among agencies for us to better understand.
Is that employee working to help implement the EU Digital Marketing Act, or are they just observing? What's their role there?
So as a general matter, when we do these details, they're focused on antitrust enforcement, enforcement of the competition laws.
This is in Europe, though. This is the implementation of a new law.
So
how does that impact antitrust law in the United States of America?
So these laws, as you noted, govern Europe. If the European Commission is working on implementing them, that's work that they're doing. Our work is focused on enforcing the U.S. laws. These types of details across agencies.
Right, but that begs the question, and I'm looking for. I'll move on because the 5-minute format is ridiculously absurd. We can't get a full answer or full question. So I'm hoping that maybe you or your team will respond more fulsomely as to why we have someone there, even observing the implementation of an EU law that is not here, unless you're intending to support something like that here. Are you familiar with someone named Rebecca Kelly Slaughter?
Excuse me?
Are you familiar with someone named Rebecca?
Yes, she is my colleague.
Yes, right there.
She's here.
So I have a quote from her. Interesting. Well, glad you're here. She's called for an equity, inclusion, and anti-racist agenda in the antitrust enforcement. Yet, antitrust enforcement typically is focused on the consumer welfare standard, right? So do you agree with Ms. Slaughter, Commissioner Slaughter's call for equity, inclusion, and anti-racist approach to antitrust enforcement?
So let me say, first of all, it's just such a huge privilege to serve on the commission alongside Commissioner Slaughter. She has thought so hard about how do we make sure we're using all of our
That's
tools.
beautiful. We only have 5 minutes.
protect
Send me a
people.
letter telling me how glad you are, please, but please respond to my question.
So she's thought an enormous amount of these issues, and I won't claim to speak for her. The way
I'm not asking you to speak for her. I'm asking whether you agree that that is the appropriate approach and when it's a de facto departure from the consumer welfare standard.
So we enforce the laws that Congress charged us with. That includes prohibitions on unfair methods of competition.
So not to interrupt, but to interrupt. You're not answering my question. My question is real specific. Do you support and agree with this new approach, which was what it would be, because it'd be a departure from the consumer welfare standard? Do you agree with Ms. Slaughter's call for equity, inclusion, and anti-racist as a basis to examine antitrust violations?
So again, we examine antitrust violations under the laws that Congress wrote.
Can you name a single law dealing with antitrust that obviates the consumer welfare standard and replaces it with an equity, inclusion, and anti-racist standard? Any statute? Federal statute.
The statutes are worded broadly. We look closely at the text of them as well as any case law.
Can you give me one that would facilitate obviating the consumer welfare standard and replacing it with the equity, inclusion, and anti-racist standard?
So Congressman, look, you're right. There aren't, cases on these specific questions. I will say when Congress was passing the anti-monopoly laws, they were doing so because they were worried that concentrations of economic power hurt everybody.
That's right.
That's
right. But that's from that point of view is how the consumer welfare standard developed and evolved. And now if you were to take the equity, inclusion, anti-racist agenda and use that as your new standard, you would have moved away from statutory and case law and tried to impose a new standard. That's the point I'm trying to make. And that's the point you're not responding to. I would ask that maybe you or Ms. Slaughter even, I don't, whatever, would respond in the future so we have a chance to get to the bottom of that. I appreciate you being here. Thank you. I yield back.
The gentleman yields back. The gentleman from Maryland is recognized.
Thank you, Mr. Chairman. I do want to start by commending Congressman Buck and Gates for their comments earlier today. I was pleasantly surprised to hear the affirmative comments they made with respect to the FTC, but also legislation they're working on with Ms. Jayapal that I think is important and critical legislation that could be very useful. I kind of note that we haven't had hearings on legislation like that. We've had a lot of hearings for the weaponization issues and a lot of hearings trying to attack the Biden administration in various ways. But we haven't had any hearings on affirmative legislation that would have an impact on people in these markets. And I'm on the antitrust subcommittee, and I think we've had 2 hearings there. We had one Mr. Massey put together that dealt with agriculture issues. I think it was meatpacking in small entities. But it wasn't as explicitly an antitrust hearing. It just so happened that the witnesses at the table noted that the big 4 companies that are dominating that industry are the ones that are crushing small farmers and running them out of business and increasing prices. But and I requested at the hearing some sort of approach that would try and address that concern, but nothing's come back yet. And I would note this too: we've got matters pending, in the United States here before your commission or, Department of Justice. Some of it have been mentioned today already, the PBMs, Ticketmaster, JetBlue, Kroger-Albertson merger, the Microsoft matter that was handled yesterday. The subcommittee on antitrust has had no hearings on any of those issues whatsoever. So I know this is an oversight hearing with respect to the FTC, but might make sense if we take a moment and have a little oversight for ourselves on what's going on here on the subcommittee. Just a few minutes ago, it was raised that about a subpoena that the FTC had issued, and I guess the comment was that it was overbroad. But I did want to raise this as well. The Judiciary Committee on May 25th, 2023 sent a document demand to the Department of Justice that demanded, and I'm quoting, all documents and communications between or among the Department of Justice and the Internal Revenue Service referring or relating to any investigations involving both the Department of Justice and Internal Revenue Service from May 1, 2023 to the present. Now, we'll set aside for a moment that would include grand jury materials potentially, which of course they can't turn over based on a letter like this, even from Congress. But if we're gonna throw rocks, let's make sure we're not in the glass house, because that is beyond overbroad. And I think it's these, and this isn't, I just picked one out of many, but there's a lot of requests that this committee has sent out to the administration and in some instances to private companies, depending on whether they're on the good side of the Republicans or not. And I think we should be very careful in making sure we're using the power of the committee and the House of Representatives in an appropriate way, just like they're asking the FTC to do. And then I did want to close with this point. That's with respect to the recusal issue. That's been discussed quite a bit. And I think it's been addressed in Judge Boasberg's opinion. I thought made it crystal clear why you didn't need to recuse yourself. And in fact, he said, in judging the motions that had been filed to him, that it wasn't necessary or even appropriate. But at the same time, this committee again is ignoring one of the most obvious issues with respect to recusal and ethics, and that's with respect to the Supreme Court. We had 35 members send a letter to the Speaker and to the committee chair, raising the issues, and we've all heard of them. Justice Thomas, and he's got billionaires buying property from his mother and taking him on yacht trips and the like. And Justice Alito had similar sorts of issues. We sent a letter to both the Speaker and the committee chair asking to have hearings, that we should take a look at a code of conduct for the Supreme Court justices, that we should consider whether there should be rules in place with respect to recusal for members of Congress. To the best of my knowledge, there's been no response to this letter. But more importantly, no steps that have been taken to try and address the issues that have been made very obvious by the conduct of Justice Thomas and Justice Alito. And that's just the beginning. So I would move for unanimous consent to have an op-ed from Jesse Wegman. Does Justice Alito hear himself? And then Daniel Buguzlaw, I think, Samuel Alito's wife leased land to an oil and gas firm with the justice while the justice fought the EPA. And then the letter from that's dated April 17th to Honorable Kevin McCarthy and Honorable Jim Jordan, and is from 35 plus members of the House. I would ask that all of these be made part of the record.
Objection. Gentleman from California, the gentleman yields back. Gentleman from California is recognized.
Ms. Khan, there's a Wall Street Journal column written by Christine Wilson. She resigned from the FTC because of a range of concerns over how you discharge your duties. But what caught my attention was the censoring of her dissent in the Meta acquisition case. Severe disagreements around here are par for the course. We go to great lengths every day on this committee to demonstrate that. But we sort out our differences by freely exchanging our views, confident that this process will separate truth from lies, wisdom from folly. A free society depends on people knowing the difference for themselves. Censoring speech is utterly destructive of this process. Can you explain why Commissioner Wilson's dissent criticizing your conduct was censored?
So, Congressman, I couldn't agree more that type of debate and discussion is critical. Congress designed the FTC as a multi-member commission, and we really enjoy internally those discussions and debates.
Well, obviously not, because her comments were in her dissent were censored. So why was that? How do you explain that?
So the way the commission procedures work is that I was walled off from those decisions. As the majority of the commission explained, they were identifying non-public information relating to staff analysis and material protected by deliberative process, that we have longstanding FTC policy adopted during the Reagan administration that says we don't disclose that type of analysis because we don't want to chill.
Well, this was specifically criticism of you. Did you have any discussions with your colleagues over this?
No, again, I was totally walled off from the proceeding.
So what do you see as the role of government in determining what is misinformation, or for that matter, hate speech?
The FTC is focused on deceptive advertising. So I guess, if a company says something is made in America, but it's actually made in China, that from our perspective is fraud and deceptive.
Well, you were discussing Twitter just about an hour ago. Do you see the government having any role in determining what is misinformation or what is hate speech?
We're not involved with that. Again, we're focused on deceptive advertising like made in USA fraud. And that's really what we're focused on.
Let me ask you, what's your view of capitalism?
Excuse me?
What's your view of capitalism?
The FTC's job is to promote competition.
No, what's your view of capitalism?
Could you explain what you mean by that term?
Good system, bad system, what do you see is its strengths and weaknesses?
So I think open, competitive, robust, resilient markets are critical to America's economic success, and the FTC has the honor of playing a really important role in ensuring that our markets are open and competitive and position America to compete globally.
Of course, the beauty of a capitalist system is the fact that consumers every day vote with every dollar they spend on what the economy will produce and at what prices they're willing to pay. Do you see a role in government in interposing its judgment for theirs?
The role of the FTC is really one of a referee. We believe in open competitive markets, but in order for these markets to deliver good outcomes, we need to make sure that companies are playing by the rules of fair competition. That's the job that Congress gave the FTC, and that's what we do.
Well, I think you go much farther than that, and I certainly hope that you'll take to heart the economic criticisms that you've heard today. Mergers, for example, generally occur when companies determine that it's going to improve their efficiency and productivity and hence their ability to serve their consumers, and that grows the economy and it helps consumers. And I'd urge you to be very careful, and your colleagues, very careful and very humble with your powers. Because when your decisions harm the economy, you're also harming your administration. The average consumer might not follow the day-to-day decisions of your commission, but they know how they're doing in their own lives. And I'll yield the balance of my time to the chairman.
I'll wait, but I appreciate the gentleman yielding, but
And then I'll yield back.
Thank you. Gentleman yields back. The gentlelady from North Carolina? Okay, North Carolina is recognized for 5 minutes. Thank you, Tom.
Thank you very much, Mr. Chairman, and thank you, Chair Khan, for joining us today. And also thank you for mentioning your work on PBM reform in your opening statement. This is a very important issue for our healthcare industry and, as you pointed out, for the health of our constituents. This Congress, I've been working with a bipartisan coalition of lawmakers to address abusive and exclusionary pricing practices by pharmacy benefit managers, or PBMs. Access to affordable prescription drugs is a critical issue for all Americans, and I'm hopeful that the FTC will take substantive steps to address the ways in which PBMs take advantage of patients and providers in their pricing strategies. I know that you got a general question from Congresswoman Dean a little bit earlier, but to be much more specific, the FTC has been working on a 6B study since June of 2022. When do you anticipate completing that study? And do you have any interim conclusions or findings that you can share with us today?
Thanks, Congresswoman. As I noted, we recognize very deeply the urgency of this work because it potentially means that patients are not getting access to affordable medicines, and that, as we all know, can have life or death consequences. So we're moving with great haste. We're dependent on the companies to provide us information in a timely way. We're trying to drive that forward as much as we can in general. Historically, some of these studies at the agency have taken 4 years, 5 years. My goal is for us to be able to move more expeditiously. I should also note that if, as a matter of course, during this inquiry, we instead identified practices that we would determine are unlawful, nothing would stop us from being able to focus on some of those law violations and proceed on the enforcement track instead.
Great. And then also the FTC recently expanded the scope of its PBM investigation to include group purchasing organizations or GPOs that have opened in recent years. How does the FTC believe that PBMs might be using these GPOs, and what kind of harm could they have in the market for affordable drugs?
So GPOs are another one of these kind of entities that are not visible to consumers but play a really central middleman role in the market. We've sent out these additional requests because we want to make sure that we're getting a full 360 view of what's happening with these practices. I should also note, we've all read stories about major shortages of critical drugs. We've also received letters and input suggesting that the role of the GPOs may also be contributing to some of those shortages of essential medicines. So that's something that's on our radar as well.
Great. And given that the three large PBMs are currently control 80% of the market, I'm interested in how consolidation within the PBM industry affects patient access and costs. In addition to this PBM consolidation, the largest drug plan sponsors also own their own PBMs. So we're seeing a great deal of vertical integration as well. We know that PBMs set out to pocket costs based on full undiscounted list price of drugs, so patients don't see a lot of the PBM discounts at the pharmacy counter. And we know that some health plan-owned PBMs require patients to fill prescriptions only at certain pharmacies or providers, which reduces access. How are you seeing this consolidation and vertical integration impacting patients?
Yeah, it's such a great point. And, this is one of the issues on which we're routinely hearing from people. We opened a docket to kind of collect input around what people are seeing about PBM practices. We received thousands of public comments, many of them from patients who were concerned that some of these decisions about which medicines the PBMs are putting on the formulary or are not putting on is not being driven by what's best for the patient, but is instead potentially being driven by which is going to give the PBM the highest rebate. So I think that could be an instance where there's a conflict of interest between what's in the PBM's own interest and what's best for patients. So that's something that we've heard a lot about.
And final quick question. Do you see a role for Congress in this area as well, not just what your agency does?
Absolutely. I mean, this is such an urgent problem relating to unaffordable drug prices for Americans that I think it's an all hands on deck moment.
Thank you, Mr. Chairman. I yield back.
Gentlelady yields back. The gentleman from Texas is recognized.
Thank the chairman, Ms. Khan. Thanks for coming here to testify before the committee. Would you commit to me to provide all updates necessary with respect to the Live Golf PGA Tour merger, and you're all's looking into whatever is occurring with that?
So, Congressman, I believe it's our partners at the Justice Department that are looking at that.
The FTC is also having some look into what's going on there, to what at least the news accounts I see. But I just appreciate any updates from your office about that and the concerns about it. And I'm going to yield the balance of my time to the chairman.
Thanks, the gentleman for yielding. Ms. Khan, earlier, and I believe the gentleman from Arizona brought this up, you said people's privacy is paramount. I couldn't agree more. And as we talked earlier, I do think there's bipartisan support to deal with that, this sweeping up of data that happens, and scarier yet is FBI purchasing that data. So that is of paramount importance. But I would say the First Amendment's of paramount importance too. Would you agree?
Absolutely.
And then the gentleman from California, Mr. McClintock, asked you, what's disinformation? And you said you don't really have an opinion on that. Is that a fair assessment of your answer?
As part of our job at the FTC, we're focused on deception and fraud and that sort of thing.
Well, you wrote a couple years ago in a law review article, digital businesses such as Twitter disserve their users by facilitating the spread of disinformation. What were you talking about there then? What's disinformation?
I'm happy to take a closer look at the material you're mentioning, but as part of our work at the FTC, we've seen how fraud and scams can sometimes proliferate on these social media websites. We've launched an inquiry to try to understand, why are some of these crypto scams really proliferating on these sites, and what can we be doing?
These are the first two sentences in the introduction of the piece you wrote, again, just a couple of years ago. Digital businesses such as Twitter disserve their users by facilitating the spread of disinformation. Who decides what's disinformation?
From the FTC's perspective, it's deception and fraud.
No, that's fine. You can keep using synonyms, but I want to know who decides that it's deception, who decides that it's fraud, who decides that it's disinformation. In this case, you're talking about social media companies and what gets posted on their platform. Who decides what's disinformation, what is it?
So, Congressman, again, at the FTC, we're focused on fraud and deception. There is a legal standard about what constitutes fraud. Again, this is about...
But you didn't say fraud or deception, you said disinformation. And my concern is, again, and it's probably the third time I've talked about this, but the sustained attack on Twitter when the ownership there changed and the platform was committed to not taking down speech, not taking down posts, allowing the sharing of information, and not censoring information. And we just had a major decision last week from a court in Louisiana, a federal court in Louisiana, where they said the government was in fact pressuring big tech companies to censor, and big tech companies were willing to go along with it. Now we have a change there, and you're going after the one company that's changed how they're doing things. That's what concerns me, particularly in light of the fact that you just wrote about this a few years ago, saying this is what goes on.
Congressman, I'm glad to have the opportunity to clarify some issues here. So we at the FTC have no view on who should or should not own a company. All we care about is that the company is following the law. That's really what our focus is.
We've covered that ground. I want to know about disinformation and who decides what's disinformation. You think the government should decide that?
Congressman, the way I see it is concentrations of economic power, including over speech platforms and communications platform, that it's that concentrated power and the ability to pick who gets heard, who doesn't get heard, to make these types of decisions. That, I think, is concerning to all of us, and the FTC's job is to be promoting...
You know what kind of speech was getting censored? Do you know what the court said last week? Have you read the opinion, by the way?
I have not. It did not concern the FTC.
You know what kind of speech was getting censored? You know what the court said? Conservative speech. Conservative speech was all, the suppression was virtually all conservative. This is not Jim Jordan talking about, it's not Republicans on the Judiciary Committee talking. This is the federal judge who had the facts, 86 pages of facts, and laid out to put the facts and the law together in this opinion, strong opinion, which said it was a conservative speech that was getting censored and labeled as disinformation.
So, Congressman, I fully understand why, given the extreme concentration of power over some of these speech platforms, why people would be afraid and worried about censorship. I couldn't agree more that when you have a handful of people making decisions about what gets seen, what doesn't get seen, who gets heard.
And you think the remedy to that is for government to decide what's disinformation and what's not?
Congressman, at the FTC, our job is to promote competition. More competition means more people making these decisions, and I think that can alleviate some of the concerns about censorship that you're sharing.
Gentleman's time has expired. Chair now recognize the gentlelady is Georgia, or yes, okay. I didn't know who had walked in first, or how we go. The gentlelady from Georgia is recognized for 5 minutes.
Thank you, Mr. Chairman. Good afternoon, Chair Khan. It's a pleasure to have you before us today. I have read your testimony. Thank you for your time and your testimony. Ensuring that emerging American businesses have an opportunity to grow and to thrive is essential for our economy. And one of the most of American practices, so to speak. America is a country that is built on the success of creative and innovative ideas. The determination of grit of its people is so vital, and the endless opportunities of its society. And for these reasons, we must do all that we can in our power to support competition, as you just mentioned, and fight monopolies which crush American opportunities. A robust antitrust framework supports small businesses by helping to ensure that they are not intimidated into conciliation. It empowers the American people by allowing them freedom of choice in the marketplace. A robust antitrust framework strengthens American workers against monopolistic efforts to lower wages and eliminate their benefits. That is why it's so wonderful to have you here today. Thank you so much for being here at the helm of the FTC. You have actually been a champion of enforcing America's antitrust and competition laws for years, and America's economy is much stronger for it. And in fact, the U.S. has the highest post-pandemic growth of any nation in the G7 and the lowest inflation, with a historic low unemployment rate of 3.7%. And that must be noted here today. As I spoke on earlier, enforcement of antitrust laws helps to promote fairer competition across the United States economy while protecting consumers and workers from deceptive and unfair practices. Balancing competition and effective antitrust enforcement are critical to protecting our consumers, our workers, innovation, and economic equity in this country. Over the past 20 years, the U.S. has seen consolidation across all markets, whether it be in a nursing home industry, tech industry, or agriculture industry. Can you please comment on how this is applied in the context of large mergers that affect smaller competitors in the marketplace?
So Congresswoman, when we see mergers between two large firms, especially if they're competing in the same market, that can make it more difficult for newer entrants to come into the market. We've seen how entry barriers can be raised, and independent firms, small businesses can have a difficult time really competing on a level playing field if the merger is leading to market power that allows the merged firms to get special types of terms or discriminatory benefits that are not available to others.
Thank you. So these past two terms, Congress has actually been examining the role of big tech companies and their exercise of market dominance, which has allowed them to make a profit and to leverage their gatekeeper power over small or new companies and competitors. Can you talk about the steps that you are taking to ensure smaller companies, especially in the tech marketplace, get a fair chance to compete against bigger, more entrenched companies?
So the FTC has been looking closely at digital markets since before I joined the commission. One of the first actions that we took when I joined was refiling the FTC's amended complaint against Facebook, where the FTC is alleging that Facebook's acquisitions of Instagram and WhatsApp were anti-competitive and really helped Facebook maintain its dominance in ways that locked out rivals and really hurt consumers at the end of the day. We're continuing to look closely at mergers and acquisitions to make sure that if we worry that these acquisitions are similarly going to create dominance and allow firms to maintain their monopoly, that we're acting swiftly there.
So under your tenure, FTC has endeavored to restore meaningful antitrust law enforcement over the last 2 years. And in this process, the FTC has made some powerful enemies. Have you not? Yes, you have. I can answer that for you.
A lot of folks, yes.
So isn't the lesson learned here that antitrust agencies should trust vigorous competition and antitrust enforcement to deliver innovation and better services rather than enabling entrenched gatekeepers to continue growing through acquisition in markets?
Absolutely. I think America's history shows that when we promote fair and open competition, that's what best produces innovation and allows us to succeed.
Thank you, and I'm out of time.
Thank you. I recognize the gentleman from Wisconsin for 5 minutes.
Yeah, thank you very much. I'm not going to take 5 minutes. I'm just going to take a real brief time here. We heard some of the same pablum yesterday. I don't have a question for the witness, but we heard some of the same stuff from the FBI yesterday that, boy, we respect the Constitution and all the rest. And, but nonetheless, they are ending up censoring the American people. And it was so interesting to hear yesterday when the director of the FBI was here, and he said, well, these companies work within the free market. We can't change how they go about operating. But when you have a federal agency, whether it's the FBI or the FTC, that comes calling at your front door and they say, gosh, maybe you should be doing things a little bit differently, they pay attention. And I would use the example of the man who originated Facebook. He said in a podcast in the last year that in regards to the FBI, when they come calling, you're going to pay attention. And censorship happens from there. And I hope that you are cognizant of that as you go about doing your business. Second thing that I would say is that we talked about, entrenched gatekeepers and stuff like that. The barriers to entry that have been built here in Washington, D.C. over the last few decades are significant. And I would go back to two major bills that are over a decade old now. One being Obamacare, the other one being Dodd-Frank. We see probably the least entrepreneurship that has happened in the healthcare and finance banking industries that we've seen in decades, because the barriers to entry are so high. And I sure hope that you will respect that you, while building these regulations out here, while passing laws as happened over a decade ago in regards to Obamacare and Dodd-Frank, it has harmed the rest of America. It's harmed entrepreneurs. It's harmed Main Street America when they no longer have a bank, with their bank being consolidated into something that's bigger. So you may say that, boy, we're going to go after these big companies. Well, hell, we created them here. And I hope you won't participate in creating additional barriers to entry so that entrepreneurs cannot participate in the free market society that was built in the United States of America over the last nearly 250 years. I'll yield back.
Thank you. A couple questions I had. I just wanted, using a little bit of this time there. The gentleman from Georgia mentioned that he thought you were being treated unfairly, if you remember at the beginning. We asked about an hour and a half ago, and differently because of your ethnicity and because of your color. Do you believe that's true?
Congressman, I'm focused on really
I know you are, but just
diligently the questions you all are asking. I won't.
I know, but I'm just curious. Do you believe that that's true? Because if you watch the hearing, I was offended by it, to be honest with you. If you watch the hearing yesterday, we gave a gentleman a pretty thorough raking over, asking some difficult questions. And I hope that you know it has nothing to do with ethnicity or color. And I hope you don't feel that way. And I was wondering if you do. It's a yes or no?
Point of order.
Yes.
Oh, Mr. Chair, just wondering whose time we're using right
He
now.
yielded back his time to me.
Okay.
And he had time left over.
Thank you.
Mr. Tiffany. Yes, go ahead. Just give me a yes or no. Do you think you're being treated fairly?
It sounds like there's a robust debate among the committee about these issues, and I defer to you all.
One of the things I'd love to change is that when we ask people to say yes or no, they would. It's so hard when people come before us. And I just wanted to say one other thing too, and then we will move on. Robocalls. I know you heard about them today. It's a really big deal. You want to talk about a way that you're affecting people's lives. They are sophisticated. They're scary. People are getting in trouble because of them, and everything from Social Security to buying timeshares. It is a really big problem. I would love to, and I'm going to speak to Mr. Correa. I would love to work with him across the aisle. Love to work with whomever to do something about that issue. I have other questions for you later, but at this point, I'll recognize the gentlelady from Missouri.
Thank you. St. Louis and I are here today in strong support of the rights of workers, of consumers, small businesses, and the broader public to be free from corporate greed that monopolizes our access to information and treats employees and communities as expendable. Thank you for being here, Chair Khan. I appreciate your service as a staffer on this committee, your groundbreaking scholarship on antitrust law and anti-monopoly issues, and your record of accomplishments as FTC chair. The Commission has an important role to play in protecting our economy from the harms caused by greedy, reckless corporations that put profit and power over people. Look at big tech, big pharma, big oil, and any other concentrated industry. These companies and the profit-obsessed executives behind them have abused their power for too long, and it's time that they be held accountable. So we absolutely need to level the playing field for workers and consumers. The FTC can and is trying to help under your leadership, and I appreciate that because it makes a real difference in communities like mine. For example, in recent years, FTC lawsuits have resulted in more than $33 million provided to more than 178,000 Missourians. In 2020 alone, the FTC provided $8.6 million to people in Missouri, including St. Louis. That's real money for real people harmed by corporate greed. It's food on the table, it's a roof over a head, it's clothing for a child. Another example is the FTC's proposed rule to ban non-compete agreements. Chair Khan, as was brought up earlier, banning non-compete agreements is estimated to raise wages by over $200 billion each year and to close racial and gender wage gaps by up to 9.1%. Is that correct?
Congresswoman, as we laid out in our notice of proposed rulemaking, those are some of the estimated effects, yes.
Thank you. It's a lot of money in the pockets of workers and Black and brown people and women in particular. Can you explain specifically how banning non-compete agreements means workers will get paid more?
So what our staff did is they looked very closely at the empirical evidence that has now surfaced in light of the different state policies that we've seen. And what we've seen is that states that have limited non-competes are able to ensure that workers are moving them around more freely, though unfortunately we still see that all too often companies are still trying to include non-competes. What we've also seen is that being able to switch jobs, being able to move freely between jobs and get better job opportunities is a key mechanism that workers have to use to be able to get higher wages and better employment opportunities. When you freeze workers in place, when you lock them in place through these non-competes, that means that they're not able to go across the street, even though the firm across the street is offering them better wages or better working conditions, and that's bad for workers.
Absolutely. Thank you. And that's a real impact that will save lives. But Republicans don't like this. The party that is in the pocket of white supremacists and wealthy corporations will talk a big game about fighting for everyday people and then show up to Congress and do whatever their corporate donors want them to do. That's what these attacks, that's what this is about. So let me be clear. There is nothing unethical about standing up for workers, consumers, and small businesses. There is nothing unethical about enforcing the law against powerful and destructive companies like Amazon, Meta, and Twitter. There is nothing unethical about putting your principles into practice. But what's unethical is being apologists for the corporate greed that is fleecing our communities. What's unethical is claiming to care about workers and then selling them out. That's the real ethics scandal here, and we need not forget it. The bottom line is that the corporate monopolies are a recipe for social destruction. Any lawmakers who claim to stand for workers and consumers must advocate against dominance by large private companies that care more about profit than people. We need to aggressively enforce our antitrust laws for the purposes Congress intended, and we also need to move beyond the digital economy dominated by billionaire-owned for-profit companies. Chair Khan, you have never tried to hide who you are or what you believe, and I admire you for that. I thank you for your leadership, and I look forward to working with you and your agency on these critical issues. Thank you, and I yield back.
Thank you. I recognize the gentleman from North Carolina, Mr. Bishop.
Thank you, Mr. Chairman. Ms. Khan, is this working? Doesn't sound, yeah, I guess I hear it. Someone pointed out to me that just this morning, the FTC, well, it was disclosed the FTC sent a civil investigative demand to OpenAI. Are you familiar with that?
Congressman, this involves non-public information, but if it's been publicly reported, then it may be accurate, but I'm hesitant to share anything non-public in this.
It's on Twitter, and among it seems to be asking, among other things, for whether Chat GPT or whatever other products they have would generate statements about persons. Can you explain the gist of that, or what is the regulatory authority of the FTC that civil investigative demand is being issued under?
So as a general matter, some of the concerns that we're seeing in this AI space is that Chat GPT and some of these other services are being fed a huge trove of data. There are no checks on what type of data is being inserted into these companies, and we've heard about reports where people's sensitive information is showing up in response to an inquiry from somebody else. We've heard about, libel, defamatory statements, flatly untrue things that are emerging. That's the type of fraud and deception that we're concerned about.
So as a general proposition, and you just said something, you spoke to libel and slander or defamation issues, and I'm going to come to that because that's an issue of state law as I understand it. But is your regulatory reach there defined by, the FTC Act? Is that the basis under which you guys investigate that stuff with a company like OpenAI?
So it's absolutely true that we don't directly address those things. We're focused on, is there substantial injury to people?
Yeah.
Injury can look like all sorts of things.
So and you were speaking earlier in communication with the chairman or your colloquy with the chairman about the Twitter background of releasing private information. Was that also subject to your regulatory reach under the FTC Act because it was somehow deceptive? Or is there some other statutory source that generally puts you guys in charge of, sensitive information about people?
Yes, it's the FTC Act that prohibits unfair or deceptive practices and unfair methods of competition. That's primarily the authority we've used in these instances.
Okay, and that, that's interesting. And just for the people in the public, the operative language of Section 5 that you guys, I think, are using there and in the context of the non-compete rule that you've come out with, it just says, unfair methods of competition in or affecting commerce and unfair or deceptive acts or practices in or affecting commerce are hereby declared unlawful, right? That's the language?
That's right.
And so it's not really very detailed. Let me ask you for a minute about the non-compete rule. So you guys have this proposed rule you're seeking comments on, administrative process, then once those comments are reviewed, you guys will decide, the FTC will decide whether to proceed with the final rule. Is that the way it works, basically?
That's correct.
And so in that case, I litigated these kinds of contracts in state law for 30 years and in North Carolina. I know California has a rule that absolutely bans them. They're different renditions of law, some statutory, some made by the courts over time in states all over the country, and there have been for a long, long time. So what your rule would do would displace all of that state contract law in one fell swoop if it were made final, wouldn't it?
It would create a new floor, yes.
It would create a what?
It would, yes, it would be creating a new provision that would be determining that these non-competes are ruled unlawful.
So you would not only, and it would be per se. It wasn't. I know some of the stuff stated in your notice of proposed rulemaking that I glimpsed said it would be, that you saw these as inherently coercive or the product of unequal bargaining power, but the rule would be per se, except for a very narrow category, or the overwhelming majority would be per se, even if the people involved in those contracts wanted to make them, right?
That's the proposal. We did ask as part of our notice of proposed rulemaking some questions about whether there are adjustments we should make.
And I don't want to get into the minor details because we only got about 30 seconds left. Let me just ask you this, because if you take that example, or many of the others have been talked about. You spoke a moment ago about being concerned about concentrations of economic power. I get that. Isn't there a basis to be concerned about concentration of legal power, law-making power? So you got 30,000 state judges have made those rules. You got 7,558 state legislators. You got lots of members of Congress. You got multiple chambers in Congress. The fact that you really, as a bare majority on the FTC, could make such a ruling, isn't that something that Congress should be concerned about, how much power you wield?
So we make these determinations pursuant to authority that Congress has given us. When we promulgate rules pursuant to the Administrative Procedure Act, there are a whole set of procedural protections that go into play relating to the comment periods that we have to use to get public input. There are certain standards of review for judicial review. There are so many checks as part of this process, and it's really quite regular for administrative agencies to be engaging in rulemaking.
But you get to say what's unfair, right?
So interestingly, Congress, when passing the FTC Act, was having a debate. They said, should we actually define, should we list out in the statute all the practices that should be unfair? And Congress determined, businesses are so innovative, they'll find ways to do an end run around any of the practices we list. Let's allow the FTC to use their expertise to make sure that as markets are evolving, as business trends are evolving, that they can make sure that their statutory authority is keeping pace. So this was a determination and a decision that Congress made to use that language, and, we follow the text of the law.
Thank you, ma'am. I wish I had more time. Yield back.
Recognize the gentlewoman from Vermont.
Thank you, Mr. Chair. Before I begin my line of questioning, I just want to make note of something. Our Republican colleagues have touched a few times today on the words of a third-party auditor who was deposed as part of the Twitter lawsuit. And I think it's really important to point out, for the sake of transparency, that this deposition was filed last night, and here we are talking about it today. I believe in coincidence, I really do, but that's a pretty lucky coincidence that that evidence supposedly providing the Republican accusations today was released in such a timely manner. So I think it's really important to make note of that. Chair Khan, thank you so much for being here. Thank you for being here to the bitter end. I really appreciate your testimony this morning. I'd like to touch on a extremely timely and controversial issue, which is artificial intelligence. And specifically, I'd like your thoughts on generative AI and competition. It's tough to imagine online platforms gaining even more power, but it seems that big tech firms who control their own AI systems and access to cloud data are in a position to do just that. And I find that alarming, as do many of my constituents back in Vermont. So what I'd like to ask you is, how could AI technology lead to an even more consolidated internet landscape with even fewer choices for consumers?
So, Congresswoman, let me say, first of all, these moments of technological disruption, when you have these game-changing technologies enter the market, these moments oftentimes provide a lot of opportunity for disruption and for displacing some of the existing incumbents and giants. And so there's always a chance that that'll be the effect. I think you're right that with these technologies, we see inputs required here that really favor dominance and favor scale. So, you need huge amounts of compute, you need access to huge amounts of data, the models. Our staff recently published a blog post laying out what some of these competition concerns could be. But I think you're absolutely right that we all need to be very vigilant to make sure that this potentially transformative technology is not further consolidating market power in ways that could really harm competition.
And how would a firm use AI and cloud access to illegally expand their market power? What would that look like?
So, I don't want to engage in hypotheticals, but, the types of, as we lay out in the blog post, traditionally the types of concerns that you might have is if firms with market power are conditioning access to one set of technologies and critical inputs on firms having to also buy other services, those types of tying agreements, and especially when they're having an exclusionary effect, can be concerning under the antitrust laws.
And are you concerned about this issue in relation to the digital markets?
In general, we're very concerned about competition in digital markets, yes.
Okay, and my last time here, I also wanted to touch on another issue, which is dark patterns. Amazon Prime has reached a point where it's practically impossible to avoid. FTC recently took Amazon to task for using a series of digital tricks or dark patterns to enroll people in Prime without their consent, or to prevent people from canceling their subscription. And this is something that I hear a lot from my constituents about. Last year, the agency reported that, quote, more and more companies are using digital dark patterns to trick people into buying products and giving away their personal information. How common is it for online companies to use these dark patterns?
Unfortunately, through our work, we've seen that it is too common that we see companies using these tricks. Our staff published a report going into detail about the different types of dark patterns that we see, which in practice end up tricking or manipulating people into making choices that they're not really seeking to make. And so we want to make sure that we're fully grasping how these dark patterns are working. We've been bringing on board a whole set of technologists that are able to kind of dig deep, look under the hood, figure out what's really going on. And so it's going to continue to be an area of focus for us.
And something that you said there really struck me. It is essentially about taking away people's choice, when you're not transparent about the ways in which consumers are being entrapped into signing up for something or not being able to cancel something, that is taking away their ability to vote with their dollars, essentially, which is something we've heard about in this hearing today. What effect does this then have on competition and privacy and innovation, just briefly?
So we want to make sure that companies are competing on honesty. We don't want honest businesses to lose out to firms that are engaging in dark patterns and these types of, deceptive practices. So there's a consumer protection dimension to it, but as you noted, there's also a competition dimension.
I really appreciate that. Thank you. I yield back.
Thank you. I recognize the gentleman from Oregon.
Thank you, Mr. Chair, and thank you for being here today and for your patience. I disagree with the bitter end phraseology that was used. I think the entire conversation has been extraordinarily interesting, and I appreciate your being here to share your thoughts. I'll set this up with a standard question. Do you agree with the following statement from former Commissioner Wilson? The agency lacks the expertise and in some cases the jurisdiction to pursue the additional societal goals embodied in the strategic plan. And jumping just to the phrase unwarranted health, safety, and privacy risks. I'm actually looking at the plan right now. For example, unwarranted health, safety, and privacy risks. Tell me how those became part of the focus of the FTC, because that seems to be an expansion of what the FTC used to focus on. Or maybe I'm wrong, but that's not my question to set up. My first one.
So I think you said unwarranted safety, health, and privacy risks. Is that right?
Yeah, actually, I'm just reading from the FTC focuses on investigating and litigating conduct that causes or is likely to cause substantial injury to the public. This includes not only monetary injury, but also, for example, unwarranted health, safety, and privacy risks.
So the statute says that an unfair practice is one that causes, one of the prongs is substantial injury. Substantial injury is not defined, but for years now, the FTC has interpreted that and courts have ratified that to mean not just monetary harm, not just losing money, but certain types of harm to wellness and safety and health. So some of the deceptive advertising cases.
So are you referring to courts? Is that where you said that?
That's right. And
okay,
recently,
so just because I want to move on,
sure.
If you could provide me with the cases that you're referring to, please, so that I can see the courts that you're relying upon for that effort. Now, let me slide that aside and let me go to the next issue. This is one, of course, that you brought up in your famous paper, the Amazon antitrust paradox. And the issue is, and forgive me, I'm not an expert in this space. I didn't even take this class in law school. So my question, antitrust. So my question is, what if not the consumer welfare standard? What standard? And I'm basically lifting this right out of Bork's book. About 25 hours I'll never get back that I want to spend reading it. And my question to you is, if not that standard, what standard are you going to apply? Or do you still apply just that sole standard in determining the challenges that bigness creates?
So we applied the text of the statutes that Congress passed, and we look closely at the language in the statutes that Congress passed, consistent with legal precedent. There are some case holdings related.
If I may,
Yeah.
if I recall correctly, before Bork's learned treatise, there was a mishmash of legal precedent. You could select among almost any standard. That's one of the reasons he was so clear in stating what he thought would be the proper standard, and that is the best for the consumer. So I'm asking you, if you're going to move away from that standard, which he so artfully articulates in his book, what is the new standard?
So we're focused on the law, including the case law,
Wait. I just pointed out that before Bork, there was any number of standards. Just grab one. So when you say you're looking at the law, which law?
The Sherman Act, the Clayton Act, the FTC Act,
so those are extraordinarily. They were written to be very broad and to give you the power to try to control this economy that we've got. Bork went in and tried to find some sort of a standard against which you could measure your actions, and his ideas were accepted. I think your article, you know this way better than anybody in this room. So my question is, what's the new standard? Please don't take me into the law, and don't do that. Tell me what do you have that's better than what Bork suggested?
So in instances where the Supreme Court has said, for example, that the Sherman Act should be interpreted consistent with consumer welfare, of course, we look closely at that. But the Sherman Act is not the only statute, right? For the FTC, we're charged with prohibiting unfair methods of competition. And I think it's incredibly important for us to honor Congress's intent in creating multiple...
Wait, stop. You're a lot of generalizations. What's the standard that you are suggesting to take the place of the consumer welfare? What's your standard? Please don't give me generalizations.
So the standard depends on the statute that we're enforcing, because each statutory scheme is slightly different. When we're enforcing the FTC Act, the words of the FTC Act are unfair methods of competition. That's the standard we're enforcing. We laid out a policy statement last year that laid out in very clear, in great detail, what that standard means, reflecting a century of case law. So
I'm out of time, but I will look at your explanation, and I appreciate your time here today. Thank you.
We are going to take a 5-minute recess, and we're going to strictly adhere to that. It will be 5 minutes.
What brings you guys here? I'm Becca. Nice to meet you. Hi, nice to meet you guys. Where do you work? Which center part?
Having fun with it. We've had a lot. I went to Colorado a lot. We had a lot.
Oh, yeah. No, Open worked for, no, I know Owen.
He's great.
Didn't work for me, but.
I know. It's fun time to hear what you guys got going on. Now they're both.
No. Yeah, Copen's at, IAPT, right? Yeah.
He was at, Super Report.
I don't know.
That's how you do it.
It's a very infrequent cleanup, but radio flyer. Yeah.
Recognize the gentlelady from Texas. Florida, I'm sorry, my God.
Thank you,
Both the Texas folks and the Florida folks are going to get mad at me now.
Thank you, Mr. Chairman, and good afternoon, Chair Khan. I'd like to focus our attention on the recent notice of rulemaking and proposed changes to the pre-merger notification form requirements and instructions. So this new proposed rule would require submission of substantial additional documents from what is currently the status quo, including draft agreements and term sheets as opposed to just the final proposal for review, information about creditors, minority shareholders, officers, directors, and information on labor markets, data about workforce, including geographic information about employees, and details about prior penalties and findings by the NLRB. Is that right? Among other things.
Yes, we issued a proposal of suggestions for additional information that we'd be getting. Another key area would be foreign subsidies. So Congress told us to get information about whether firms that are looking to merge are getting subsidies from China or other countries.
Thank you. But in summary, this proposed rule would substantially expand the types and volumes of documents and information that are being submitted as part of this pre-merger review process, correct?
That's right.
Okay, and we also know that this rule, this new rule, if adopted, would substantially affect the time and the cost associated for entities who want to participate and make submissions under the pre-merger review process, correct?
Yes, people would have to comply with the new form, which is seeking additional information.
Right. And your agency, in fact, has estimated that this would increase by over 100 hours the time necessary to compile compliance documents to make this submission. And in some cases, in some of the more complex or larger cases, even much more than the 100 hours, correct?
These are some of the estimates in the NPRM, yes.
Yes. And the internal estimate also identified a cost estimated of $350 million impact for the change in the rule for compliance. Is that right?
That's on the higher end. I mean, I will say a lot of this will depend on the complexity of the transaction. If you're seeing a merger between two fairly small firms that don't have any, complex holdings or that sort of thing, I imagine it would be much less.
But you just raised a very interesting point, and it was one of the things that I wanted to ask about. So if we know going in that the time and the cost now associated with this pre-merger review process, the time's going to increase, the cost is going to increase, won't this affect the businesses that are at the lowest end of the reporting thresholds the most? They would be the least able to incur those costs and time without it affecting their overall margins?
So again, it really will depend on the complexity of the merger. If it's a fairly simple transaction, I imagine it will be much easier to comply. I should also note, this is all about what firms need to produce on the front end. And it's our belief that by getting more information on day one, that'll allow us to more efficiently and effectively administer the laws in ways that could create more certainty for businesses on the back end.
But at the conceptual level, the large corporations, the ones in fact that I believe you're probably the most concerned about, the very largest corporations are the ones who are the most capable of saying, yep, let's bring in our outside counsel and spend a couple more 100 hours, or let's allocate additional costs to go through this process. They would be the ones who could most easily absorb this change as opposed to the smaller entities at the lower end of that threshold. Now, let's go here. So by expanding the types of documents, by the types of information that you all are reviewing in assessing whether a merger should be approved and allowed to proceed, you're really expanding the bases upon which the FTC could choose to approve, seek more information, or disapprove, are you not?
We're still squarely focused on whether the merger may substantially lessen competition or tend to create the monopoly. That remains our legal standard. We're seeking.
How is it that some of the information that you're requesting, though, such as demographic information about employees or information about shareholders and officers, how would that relate back to that core mission that you all have been pursuing prior to now?
So issues relating to officers or things like potentially, overlapping directorates, those can affect, for example, Section 8 of the Clayton Act in terms of if you have interlocking directorates. So those are some issues in which, they're squarely within the confines of the antitrust laws.
So let me ask this then. The proposed rule, it's something that you all have developed in essence because you believe it would have a significant impact, correct? On mergers, on the health of the economy, on businesses. You're pursuing this because you think it's meaningful, correct?
We're pursuing it because we think it'll allow the FTC to administer the laws that Congress has charged us with more effectively and efficiently.
So you believe it's consequential?
Go ahead.
We
Last
think
question.
it'll meaningfully enable the FTC to do its job, yes.
Without a specific mandate from Congress to engage in this behavior, correct?
I disagree with that. The Hart-Scott-Rodino Act allows the agencies to get information on the front end when firms governed by this law are required to do so, and we're acting pursuant to that authority.
Time has expired.
Thank you, Mr. Chairman. I yield back.
Recognize the gentlelady from Indiana.
Thank you, Mr. Chairman. Thank you, Commissioner Khan, being here. So I want to bring a few issues, and I would like you to respond. But first, I belong to a group of people, even though I very much agree with Mr. Tiffany that majority created more companies now, too big to fail. And one of the implementers when I work in public accounting now create all this institution even bigger.
Make sure it's actually plugged in, because now I have to wait for years to charge.
Now we're going to be dealing with that. But I also understand there are some of the areas where we have now problems so big that it involves us to looking at the barriers of entry, like healthcare, and then looking what are we going to deal with now with these monopolies that distorting the market and using very aggressive behaviors to suppress suppress competitives and really not delivering value because they can't. They are not natural monopoly. We created, and we have to look at that. So I think your agency has an important function, but unfortunately, and I want you to really respond that we have a lot of concerns from the Republican side, and that agency has been politicized and agency has been used to really, the hammer and sickle and, to actually pick, a kind of in fashion to pick losers and winners. And I think, it's becoming a problem. And if you look at your even, the missions that you have and objectives, you said we really need to have more, merge together consumer protection, competition, and you want to, your agency shapes distribution of power. I truly don't believe that that is an agency. I think the agency should be, dealing with real abusers in the system that want to not have competition, use monopolistic powers. Even in the statements, it's a problem. And I think we have one common ground that it seems like a lot of time we have a lot of talk is on healthcare. But when we come to the action, is even recently, we put it on the table with President Biden's administration on dealing with, with site-neutral payments on hospitals that bankrupt in Medicare, total abuse of power, allow them to buy private practices, allow them to put these doctors in crazy non-competes, enslave them, building Taj Mahals, not paying taxes, investing billions on Wall Street and pay billions to executives by subsidies that are now countries going bankrupt on because our spending is healthcare, not delivering value, they didn't want to deal with that, and then you have a challenge now because a lot of these entities non-profit, which is really doesn't even have guidance that like next business I'm going to have is going to be tax exempt. You don't have a full jurisdiction to deal with these entities, and no one has. And I would like you to deal with that. But now my colleagues here have a concern. So, we have actually bipartisan bill, but a lot of more people here feel concerned with you that you're not going to be enforcing it properly, and you will use it as a power, to actually pick losers and winners again. So I wanted you to see how you can respond with what you're doing in this area, I think there is a PBM, probably common ground. We have that area. But if we look at that, 50 to 60% of spend is, hospitals and physicians. 5 to 10 is actually only spent on drugs. So this is a huge amount of money. How would you respond what you're doing on that, and how you would address some of these Republican concerns? Because I think your agency has some functions, but unfortunately, everything gets so politicized. And a lot of people here on my side of the aisle don't feel comfortable to give any more power to your agency.
So thanks for the question, Congresswoman. You're absolutely right. We have a whole set of work streams underway relating to healthcare markets. We're concerned about instances in which monopolistic practices or a lack of competition in healthcare markets maybe raising prices for consumers, maybe depriving them of access to quality healthcare. Our teams have for many years now been challenging hospital mergers where they've determined that the merger would either raise prices or lessen competition in ways that was harming patients. We have work underway, as we've talked about extensively today, relating to PBMs and the potential conflicts of interest that are created through their vertical integration, as well as issues that may be created through the rebate schemes that they have in place. We also have work looking more directly at drug prices and whether, mergers and acquisitions done by pharmaceutical companies may be inhibiting innovation, maybe keeping lower cost alternatives out of the hands of American patients. So that's all work that we have underway, and we're working hard to move quickly on all of that.
My time has expired, but we still need to figure out how you can address concerns of my colleague. So I yield back.
Gentlelady yields back. I recognize the gentleman from Texas.
Thank you, Madam Chair. It's good to have you here today. I'd like to talk about the Horse Racing Integrity and Safety Acts. It's called the Horse Racing Integrity and Safety Authority, which Congress created and put under your commission's rulemaking authority. I know you didn't ask for this, but you got it. And I've got some questions. They're not complaints directed toward you or your leadership, but I just like to say that I'm very disappointed in how they have operated. HISA was intended to improve safety and fairness in horse racing. It's fallen short of its promises. And some of the issues I have, I'm not even sure you're aware of. And when I'm done, I want to ask that we can sit down and talk about it more. But the FTC has allowed them to operate in a way that they are making rules, I believe, without the authority or without any oversight. There's also a budget of $66 million. My question is, does the FTC monitor how these funds are being spent and who the recipient of their budget funds are going to?
So the statutory scheme lays out the relationship between the FTC and this kind of self-regulatory organization. You're right that we didn't ask for this authority. To be honest, it's been a bit of a challenge for us fully implementing it. We don't have real deep expertise in this area. On your specific question, to be honest, I'm not totally sure. I don't think we have that authority to be overseeing how they use their money.
Okay.
I'm happy to get back to you on that.
Separately, if the FTC enforcement staff was investigating an antitrust case and thought it needed to conduct a search of a business's premise, would the FTC need a search warrant for that search?
Presumably, though I do know that I believe it's Section 9 of the FTC Act does give the FTC ability to, engage in some of that activity as well.
All right. I would just let you know that this authority under your supervision can conduct a search without a warrant. They can also impose an immediate suspension on horses and trainers and owners if there's any evidence or suspicion of doping. One of the reasons they were created was because of the deaths in the horse racing in the past, but we've seen just this year that even more deaths have happened, and I would make a case that this authority is poorly run and operating in a way that I suspect if you all really knew, you would disapprove of. I'd like to sit and talk with you all about that after this hearing down the road. Moving on, I want to talk about some of the mergers and the policies with respect to those. I'm specifically curious because I'm looking at a letter that Senator Warren sent you all in January of this year about some pharmaceutical mergers. How much interaction does her staff or her have with you all with respect to these? Do they have influence with the direction you all go on some of these investigations?
Congressman, we hear routinely for members of Congress. We get letter week after week, including from many members of this committee. We take all of that under advisement and want to understand what our members' concerns, but any law enforcement decisions that we're making on an independent basis based on the facts and law before us.
Well, I'm looking at particularly the Amgen and Horizon merger, which I understand was moving along pretty well. And it's different than some of these mergers that she mentions in this letter that I'm reading. And I know y'all probably have a copy. I'll get you one if you don't. But Horizon is an Irish company. It's a kind of a special case because it inverted in 2014 by acquiring this Irish company. So they actually left the U.S. For tax benefits. And now Amgen, as I understand it, is looking to acquire this company. They're involved in totally different drugs. And what this would do is actually bring a company back to the United States, which I believe is a goal that we all share, is bringing industry here at home. So I would also ask, especially since it seems to have been stopped right after Senator Warren sent this letter, if I could sit down with you all at some point and we talk about this one as well. Can we commit to doing that?
We'll be happy to have a follow-up conversation with you. Yes, Congressman.
I appreciate your work and thank you very much for being here. I yield back.
Gentleman yields back. We are going to take a recess when we have to vote. As soon as votes are completed, we will be back. Thank you. You're going to get a longer recess now.
Finally done. Yeah, I told him about that. There's still live streaming.
Oh, thank you.
There's still live streaming. FTC live streaming. That's been going for 3 hours? Damn. lot harder. Here you go, man. Okay, done with the live stream. It looks like they're just leaving now, so. Actually, now a lot easier. That would have been a way lot easier. Ugh, I'm stupid. And it's like.